You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Our guest today is Jakob Norman, who is the managing attorney for Trial Lawyers for Justice and a very distinguished trial attorney himself. And Jakob, thank you for being on the podcast.
Good to see you, Kenny. How are you?
Good, man. Good to see you as always. I know you are traveling all over the country, if not the world, right now. Where are you today?
I woke up in Wyoming yesterday. I woke up in Montana today, and I will fall asleep in Spain at the end of the week.
Nice.
Oh, and I have another night, I guess, of depositions out of state midweek. So, yeah.
Well, I hope whatever is taking you to Spain is super fun and maybe spring breakish related.
Absolutely not. It's Jerry Ball with Sean Claggett.
Well, that'll be fun.
Yeah. So, hopefully, I think we're going to do some fun things, but kind of excited to hear about his most recent Colorado victory in the workers' compensation case that some folks are talking about recently.
Yeah. Workers' comp, bad faith case, I believe, against Berkshire Hathaway.
One of their, consolidated companies. Yeah, I forgot the name of it, but that's exactly right. That they were providing not the level of care that the patient needed, and the verdict was over 140 million bucks. So pretty awesome.
That's incredible.
I think those are cases that probably across the U.S. every day people turn down, kind of not even thinking that they could ever end up in that kind of category.
I agree. Absolutely. All right. So today we're going to talk mainly about trial tech, but also kind of see wherever the conversation takes us. You were kind enough to come out to our Trial Lawyer Association in South Carolina last summer and talk about AI. Again, today more specific to trial tech. But in talking about trial tech, can you describe your overall approach, and then we can get into some of the specifics?
Yeah, I don't know if you're going to like it, but I'm happy to talk to you about it. And I think it goes to kind of one of the nuances of our profession. And I have a very personal belief that I don't think a lot of people share, but you asked me, so I'm going to tell you. But I think you have to master your own tech. And to the extent you master your own tech in the courtroom, you're not going to be yelling across the room for somebody else or doing this or that. Now, it's good to have someone to blame if something goes wrong. But I think it also, in my opinion, and you can talk to juries about this, but does it make you look like you're not capable of doing what seems like basic stuff? And we can break it down. I'm sure you'll break it down. But if you can't advance a PowerPoint, some jurors, I'm sorry, are going to wonder how hard is it to hit the next button. And just where tech is today, most tech isn't even hard. So without talking about specific tech quite yet, I would say you ought to be able to use your own tech. And it's no different than, remember, when PowerPoints came out and they used to say, well, you better have a plan if your PowerPoint, it doesn't work or it doesn't load or it doesn't do that. What's your plan if your trial tech, falls apart? If you're hiring a trial tech, is that fair for your client to pay 3,000 a day, 4,000 a day, 5,000 a day for a trial tech? I don't always think so. And are you willing to take that risk? So in other words, you can look at it however you want, but is trial tech difficult? No, not if you spend a little bit of time with it. And how much does it make you be able to master a little bit more? So I'll kind of quit with that and we can go deeper, but my general philosophy is you ought to be able to run your own one. And what are we talking about for main trial tech? We're really only talking about slides and exhibits. How hard is, if we're only talking about trial, how hard is that? Everybody ought to be able to click forward or backwards on a slideshow, and they ought to be able to pull up an exhibit.
Yes, that was going to be my next question. For you mastering your own tech, knowing how everything works, especially if there's an issue, being able to troubleshoot it because you understand the program or software, what you're trying to accomplish. Are you also, in essence, running your own tech throughout the case?
Absolutely. And I do, I mean, I have a recent example where the tech failed, but it turned out it was a faulty HDMI wire in the court system, and it was a nightmare. And before we figured out that was it, everyone's like, I told you, you ought to hire a tech. But what happened is on all the testing it worked, but a good cord goes bad sometime. Well, guess when it happened to go bad? It happened to go bad during opening and it was just kind of flashing. And it would stay on long enough that you could see it, maybe 5 seconds, then go off for a second, back on. And so ultra annoying. And it looked like to some people, well, you should have had a tech. Well, what I did is sent my friend running to the store and we replaced the HDMI cable at lunch and for 2 more weeks never had another issue. Now, that's a bad story, obviously, but we ought to talk about that because your real question is do I run it? The answer is yes, I run it, or my associate runs it. And again, the things that we're using are basic. I don't know what the most advanced trial tech system is out there, but we only use two pieces of technology and they work. And I think everybody that's listening is very capable of running them on their own. Do I think everybody can make the most beautiful presentation in Keynote or PowerPoint? No, I don't think that. But everyone can advance a slide and everyone can click on an exhibit number.
And the two pieces of technology you're talking about, are you talking about PowerPoint and Keynote?
No, good point. We're a Mac-based firm, and so all of our lawyers use Apple computers, and Keynote is the primary design software in there, of course, or for presentation. I'm sorry, and Macs run PowerPoint just the same as PCs. Excuse me, but we think Keynote's cleaner, crisper, and frankly just better. There's better and different animations and transitions and some pretty cool things it does. If you're not talking about just basic click forward, that's Keynote. So all that is slideshows. The only other piece of software that we use is TrialPad. And TrialPad has about five things you can do when you're in that mode. And I don't know if you've used it, Kenny, but to me, it's some of the simplest software. In fact, I was in showing it to Nick one time, and again, it's something he hadn't seen or worked on, and he instantly saw how easy it could do. And in my last trial, Courtney Raleigh hadn't ever used it personally, and then she was using it for my exhibits while I was up. It's that easy.
Yeah, TrialPad is super simple. Easy integration, easy to use, simple, straightforward
Yeah,
functions.
there's even like a save my life button. You can hit, it's like blank and it tells you it's on there. It says trial pad for iPad on the court screen, freeze or whatever, which means you can look for anything someone's yelling at you to look for, and the screen stays the same, but your screen looks different and present. Like, I don't know how you screw that up. Um, but it's something you can practice at home with, you can practice at the office with. And believe me, I don't get anything from TrialPad or Apple. I wish I did, but I don't. They are, between Keynote and TrialPad, I don't think anybody needs anything different.
Yeah. Some of the nuts and bolts going into the planning for whatever tech you're going to use. Again, even if we're talking about um, a laptop, an iPad, two pieces of software, what are you doing or having your office do in advance just to make sure courtroom's good, court staff is good, judge is good, that you've just got a feel for what technology is going to be used and where.
Yeah, great question. And we do a lot of stuff outside of our jurisdiction. I think most people, if you're doing there's a time in my life where I'd go to the same courthouse about 4 days a week. I was doing both, civil and criminal, and you just can't avoid being in the courthouses every day, whether that was circuit, district, or even federal form. And you get to know those. Those are no problem. We were all there when we saw that they were upgrading the courtrooms, right? Like anyone that's been an attorney for a while remembers when there was nothing there. And then there's maybe just a TV. And then there's maybe uh, juror specific screens. And then there was where the judge could control it. I mean, I've watched the evolution of all this in my career where you have now what we would consider an actual high-tech courtrooms. Some are built on floors where they can run the cords underneath the floors. But you gotta go test it out. And more judges are doing final pretrial conferences live. I don't know how it is in your jurisdiction, but even if they're not, you ask them in your final pretrial conference if you or your team or however you're going to do it can come check out the courtroom. If you even sometimes I tell people, do you have even a tech guy? Maybe you're not the techiest person or the techiest firm, but who do you use if you have a new computer or computer problem? Maybe take them down there, make sure you have all the stuff you need, see if something seems to be missing, and move on from there. And so it just takes minutes because right now we're down to also one plug. And that used to be messier too. We're down to basically everything's HDMI based or an HDMI, you know, um, some kind of adapter of some kind, but really we're pretty simple. And then you hear weird things like in my last trial, the court tech said, well, Macs don't work on our system. I was like, well, what do you plug into, sir? And he said, well, an HDMI. I'm like, well, HDMI is agnostic. It doesn't care what it's plugged into. If it's receiving a signal, it's going to put up any computer. So you just go test it out, see what it is. Some things, like mine was a weird case where we did all that and it still failed coincidentally during the opening. But what do you do with it? What do you do if the slideshow goes down? Well, you better be prepared to talk anyway, or ask for a break, or in my case, let it flash the whole entire opening and sweat and wonder and just be annoyed. But again, it's usually a simple fix. So ask it, if not earlier than the final pretrial conference, if you can have a little bit of time. Judges want you to take that time. Why do they want you to take that time? Because they don't want you to waste it when the jury's waiting. Because if you get there on board hour morning and you're going to go to opening and you're like, oh, Judge, could we have a little bit more time because we never did this? Do you mind giving the jurors a longer lunch, or we're not quite ready yet? Can they stay in the back room? Then tension builds and likelihood that everyone's mind is working as clear as it should is kind of slowly going away. So just get in there early, work with the court, apologize, take people chocolates that need chocolates, do whatever you got to do.
Well, and I mean, the thing is for some of the younger attorneys, especially, the court personnel actually enjoys when you come out there, they're kind of genuinely interested in what it is you're going to show, what you might have, especially if you've got something new or interesting. Uh, they want to be helpful. I mean, these people, by and large, these are civil servants who are not doing it, because of the incredible amount of money that the state or federal government's paying them. So you show up on a random Tuesday or Wednesday, they get to show you around. You start asking about stories that they have. And, if you're like, hey, what do you think I should really avoid? Anything that you've seen go wrong in this courtroom from a tech standpoint? They love telling stories about when tech goes wrong.
And
Um,
actually, yeah, you're right. And when they're open-minded, what you said is you can also teach them something. Like one reason I found out one court thought apples don't work with them is because people were bringing 4K compatible apples in. And what that does is present a couple glitches, but on your Apple, you just go change the resolution and you can overcome. Maybe not every TV in a courtroom is a 4K TV, so it might look a little glitchy here and there. And they love now to know the answer because guess what? They might have been wrong that their TVs don't work with Apple when it was really their TVs aren't 4K. But next time someone comes in, they're like, hey, let me tell you, if your computer's outputting 4K, change that setting and everything's going to be good type thing. And exactly what you said, plus you get to go say hi to the clerks. You might not have seen them in a while, if ever, for some of us, if you're coming in late. Introduce yourself, ask them if you need to know anything else about the court. But you're right, people are proud of these rooms that the taxpayers paid for, these courtrooms, and they like to show them off. They like to show you their capabilities and, to your point, tell you their potential vulnerabilities.
yeah. So Jacob, out of curiosity, objections that you've run into, if any, when it comes to tech, motions and lemonade that you've run into when it comes to tech. I'm just thinking about some of the questions that for the listeners sitting there thinking, yeah, I want to do this. Yes, I know PowerPoint or Keynote. Yes, I can either have TrialPad or understand how to use TrialPad. Um, any of the hesitations or hurdles that might be getting in people's way. I just want to do as much as we can to kind of assuage any fears and just say, look, man, just go for it, but also have a backup plan.
Kenny, I hope you're prepared for disappointment. I wish I had something magical like that. I will tell you this, almost no lawyers and almost no judges talk tech. If you can talk tech, no one's standing in your way. If you're unsure about tech, they will stop you. I have never been stopped. My friend Alvin and I last year in Missouri tried a case in a courthouse that hadn't had and I think it's over 100-year courthouse, old courthouse as well, hadn't had a trial in a decade, and the judge warned us, hey, like we don't have tech. So we went to the local Costco. We bought a couple TVs, a HDMI splitter, and we created the tech. And we gave it free to the defense as well, because that's the other thing that starts to look funky to me, like appearances. We all ought to be aware of how it looks. If, and this isn't quite answering your question. So, first answer is no. I think it helps me because I'll talk whatever tech talk needs to talk. And then their tech person, if they have one, gets it that I get it. Defense has not thrown any motions my way. You would get the standard ones like, I shouldn't be able to show evidence in the opening or something like that. I don't count that as tech. I count that as just them wanting to see my opening before. I will give a trick on that. Can we talk about that for one
So you can
sidebar?
talk about anything you want. Yeah.
Anytime the defense asks to see your slides before they go up, please listen right here. Take everything out of them that you know is in, maybe a jury instruction or something like that. Take your color out, take your fancy parts out, take your font out. If it's because what they really want to see is your demonstratives more than anything or potential evidence, right? But let's pretend like you have a theme and the theme has like a blue stripe and a background of some kind of watermark and stuff. Take the blue stripe out, take the header off. Like I always have a stripe that tells people what's on that slide. If they ask to see my slides, they don't get that. This is step one. So first, sanitize your slides, right? Second, change them in all a big random order. Why? Because you're not trying to be weird or you're not trying to deceive. They've asked to see what you're going to show the jury. What they're not entitled to do is know what your opening statement is. That wouldn't be fair. So what I do, because that wouldn't be fair, is I sanitize them. They still get to see what my demonstratives are. And frankly, a lot of my demonstratives come from Google image searches and stuff like that. They're very general stuff. Or the other ones that are pictures of your client will hopefully, most courts will let you do that, but you better have given them in discovery, right? Just very basic stuff. Or what, pictures of deposition, or maybe pitch of a page of a deposition, or maybe a jury instruction. And some judges don't like attorneys talking about jury instructions, and some, judges only want you to talk about the evidence that they may see. And it's like, well, judge, they're going to see this deposition page. I can tell you that for sure. So anyway, if you're forced to do that, take away all the stuff that you think makes the slide look better and leave the content, the portion that you're worried is objectionable, change the order, literally slide them all over the place and turn them over. And that's one thing. The other thing, if they're one of those people who are really fighting you on your slides, ask for time before the jury gets in and say, Your Honor, I want to show you some things that I'm going to show in my slides. And the defense is not agreeing to this stuff. And we need a little bit of your time in order for you to make a decision. And then with the judge, you show him or her the same messed up slides that I'm telling you should have made already. And they like to go through it because the judge in 3 minutes can go through it, or you can deal with objections all throughout an opening, right? So I know that was a sidebar, but my gosh, you guys, and I've heard this from several people, oh, the defense made us give them our slides. No, they didn't. They're asking to see what you're going to present. You need not tell them what you're going to be talking about during that slide. I almost said argue, but it's opening statement, not argument, right? That's not what they deserve. And frankly, if they're your words that you've now put on a slide, they don't get to see that. That's different. That's not what they're actually entitled to see ahead of time. What they're entitled to see, in my opinion, which is fair, if they ask, some defense folks don't care. Just go do your thing. We'll figure it out. But if they care, if the judges ruled this, show them the things that may be objectionable. That's what your obligation is. But my gosh, if you give them your slides in order with how they look, we've actually seen defense try and emulate our slides by the end of trial. Don't give them that. Take out the stuff that doesn't matter. What your color theme is and stuff like that just does not matter.
Yeah, Jake, going back to demonstratives and some of the images that you might pull from Google Images, what are you doing, if anything, in terms of AI created images for use, and be it open with witnesses or close?
A little bit of both. And you don't know what both is because I didn't tell you. So sometimes I'm asking I am trying to explain this concept to a jury, and what picture would help it resonate? And AI, and then it will send me something and I might not like it. I'm like, all I write back to AI is try again because it doesn't take anything personally. Like if I asked you to write a response to emotion and all I wrote to you was try again, you might think I'm a jerk. The good news is AI knows it's a workhorse and doesn't care, and it instantly gives you more ideas. So first of all, make sure what you think is an image that's resonating in your head might resonate in other people's head as well. And you can even ask it that. I'm thinking of showing an iceberg where you can only see the tip and a whole lot below to explain this concept. Do you have any ideas that might be better than an iceberg? That's actually how I would talk to AI. And it might say, hey, your iceberg idea is good, but have you thought about X, Y, or Z? So, step one, you have a mini focus group with AI to see if the image you're thinking of using would make sense. One. Now, if you're not good at like Photoshop or color matching or anything like that, then you can go to AI and say, I want you to make an image that does this or that. I, again, based on the theory I told you early on, is I own a bunch of this stuff. Even if I take from Google or any of the services, if pretend like you can't find something on Google and you want to go to Adobe and buy a photo or Shutterstock or you name the service, it needs to look like the same person did the show. So I will often use color matching in Photoshop or even Keynote and change the red levels or the green levels or the blue levels in order to look like everything I made was made by me. But if you just go to Google and you find the best picture for that, and this one's a cartoon and it looks good, but four slides down, the picture you use is real people and it looks like they're drawn, let's say it's an illustration, but they're very good looking. All of a sudden, to the juror's mind, it's like, wait, this is clip art. And I don't know if you want, but for the video portion of this, I'm happy during this section that we can kind of show how I use these colors and pull it together. And one thing we know is the most clicked on color on Instagram and other social media is blue. So I use a clear white background and a blue stripe. And the blue stripe, I always tell the jury what's on that slide. And they start to anticipate this and know it. And in the background, I always have what I'm trying to beat into their head. On a benzene case, there's a benzene molecule. On a med mal, there's a medical cross up there. On a traffic case, there might be striped lines or dashed lines, depending on what makes sense. And it's opaque, you take the opacity from 100%, turn it to like 20, and every single slide in the same place has that same sign, and they never ever forget what I'm trying to get through on this. And you don't tell them that, but that becomes the theme, right? Again, every single slide in our benzene case has a benzene molecule, about 20% opacity just sitting there. Who cares what's over the top of it the whole time, but same place. And you don't go crazy on colors. You don't go too far this way or that way because you're just trying to give them another way to understand or remember the evidence or the story that you're trying to tell. And it just really, needs to look professional. And that's why I'm saying if you're not capable of that, that is something you might hire out, but you got to own it because hiring someone doesn't mean they just magically make up your story. If you're not giving them your story, they're just going to make something and you're conforming your story to them. And I think that's a mistake because
Great point.
graphic artists will do their best, but you don't just get to say, "Oh, I'm paying you, you figure it out." No, you better write your whole statement. Almost think about like you're writing a script for a movie, the written part, like the scene part. It's dimly lit, characters are, 30 feet from a beach, blah, 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 blah. And then the dialogue, right?
You
And
pretty much just wrote the opening to Jaws.
I, I didn't mean to. But yeah, right. So if you could do that and take the time if you need to hire someone to do it, great. I would also tell you for anyone that has, kids over, probably 12, they're better than a decent amount of attorneys I've seen. But anyway, that's what you ought to do. What are we witnessing in reality, Kenny? People aren't doing this till a couple days before, and by then it's too late. And the defense did something in my last trial when they got up to close. They're like, and our slides routinely, and we interview jurors whenever we can, and sometimes the judge kicks them out and makes it nearly impossible, and for you to do it. But we repeatedly are told one thing: our slides were great and helped them understand the story. But we've seen two different trials where they pointed at the defense and said, you need to make slides that look more like theirs. But the last one, a well-known med mal national trialer got up and said, well, I don't have fancy slides, but so they had no slides in their opening, and they were forced to make slides by their closing because we were controlling a lot of the narrative with the slides. Now, this doesn't mean you win. It means you're giving your audience another opportunity of a way to learn the story.
Are you also mixing in your, just your block paper with the easel, also mixing in things that are super low tech to be like, look, it ain't just the high tech, fancy slides. If we need to write it on a whiteboard, if we need to write it on a piece of paper, we're, just with the butcher block, we've got all those things covered. So you're not getting pigeonholed as, the fancy pants tech guy. You're showing that, look, we've all we're doing here is presenting all the evidence in a way that's most effective and kind of touches people on all ends of that tech or uh, relational basis, however it is they relate to the visuals.
Both, Kenny, and I'm going to tell you exactly. Of course, absolutely. So, Brian and I were in a case where the literature mattered, and the literature was against us. We had a case where the common known outcome of exposure to benzene, sorry, is acute myeloid leukemia. Ton of research on that, hundreds and hundreds of articles. And why? Because it comes across, they suffer from it decently quick. You can figure it out. Our client had multiple myeloma, came 26 years later after the exposure. So what do you think on research there is on that? Almost nothing. So we went to trial with a case where there wasn't hardly any literature supporting us. But our argument was like, well, if it can cause that, which is down in the bone and cause damage in these cells to recreate, that's what that is. Well, guess what? Multiple myeloma is the same thing. It starts in the bone and the cells, get out of control. And that's what cancer is. That's all cancer really is at its base level. So don't fall for there's not a lot of articles. Now that's closing more. So let me tell you what I did in mid trial. I had a butcher block. And what you learn about some of these, toxic kind of things is how in these articles that you're reading for any kind of epidemiologist or whatever, there's usually 4, 5, 6 authors' names in them, right? You almost never look the authors up. You just like, oh, this is the article. It's in the New England Journal of Medicine, or okay, cool. Let's read the article. Well, actually, we're lawyers. Let's read the abstract and see if that's good enough. Okay, now we can read the article. If you look up each person's name, what you find in a lot of oil and gas toxic torts is like the chief toxicologist of Exxon's named in there. And you're like, oh, well, this is interesting. Why would the chief toxicologist of Exxon be the author of something saying this doesn't hurt people? In other words, their product doesn't hurt people, but he's getting paid for by the company that created the product that's accused of hurting the person. So what I did is there's 6 articles that I really wanted to focus on of 350. And imagine this. So 6 names going down, 6 red boxes to the right of each name, and to the right of each red box, 6 green box. This was all pre-hand written, so I could go a little quicker. And this is butcher block, what you're talking about. And I'd ask him, hey, did the Tesoi study, was that funded by oil and gas or authored by anybody that had anything to do with oil and gas? And what do you think the guy on the stand said, Kenny?
Uh, well, do you waffle or you just come out and say yes? Or do you say no?
I don't know. That was what he said. He said, I don't know.
No.
So guess what I did? It was. And in the red box, it red means bad, right? So I use the right colors. Up top, it said sponsored by oil. Yes. And no was green. So I gave him the answer, and you can do that. I just clicked the red box. And the first three, of course, were the oil companies. He didn't want to admit it. And I kept clicking the red boxes. And on the last three, guess what? They were the neutral ones that said, hey, we think there could be a causal connection, but more to come. I said, did oil and gas have anything to do with paying for or being the lead authors on those studies? I don't know. Guess what I did? Yes, yes, yes. Now that's butcher board, right? What do I do for closing? I recreate that, but cleaner. And now I have the same names, the same boxes, and I go over. So now I have, my writing's not the best, and that's why on some of this butcher box stuff, you should pre-write it out if you know you're going to follow some kind of format, even if it's just making the boxes so your spacing's right. Because if you start too big, you get small and stuff like that. But anyway, plan on not only the regular stuff, but how do you remind the jury about it? Two ways. You take a picture of it and put it in there, but that's kind of you missed an opportunity to make it cleaner, but now they're seeing it for the second time, Kenny. They took the old-fashioned way that how we grew up, or I grew up, and they watched it live, but you're reminding them by a nice, clean, perfect box, perfect check, perfect everything, and reminding them what they saw live. So you should never just do one. But there's also more, you'll see defense, the big defense firms are now starting to lead their expert witnesses off pre-designed slideshows. So it starts off like, you know, opinion number one, and they flash it up there. Opinion number two. And the defense is getting better at using slideshows to tell their story. Now, thank goodness they're still not good at presentation or human storytelling very much, but they're coming on, they're doing more and more of that. And it's not a bad visual to use for your own experts. Don't think just because I'm saying I'm seeing the defense do it more that you can't use it. Dr. So and so, did you make opinion in this case? Yeah, blah blah blah. Go over all the stuff you have to do and show them on the screen. Let them read it a couple times. Let them think about it. That's how they're learning.
Jacob, out of curiosity, where are you with experts who have kind of their prepackaged PowerPoint or keynote that they like, and they're invariably a ton of slides with a lot of words on them, but it's a PowerPoint that expert likes either for deposition or for trial, and working with the expert to make it more presentable, more storytelling form.
Perfect. In deposition, be really careful because it's going to be an exhibit, and a lot of our depositions are recorded anyway. So do you actually want that out there forever? And if so, give them more latitude in the deposition for trial. Clean it up, shorten it up, take out all the words. And you have to convince really smart people that not everyone's like you, especially me, doctor. I'm just a Wyoming dummy. So what I need from you is, and what the jury's going to need, and it's not because we're dumb, but it's because we don't spend all day every day thinking about these things, but we need shorter sentences, less words. Is there a picture that could also help tell the story? You have to push your experts, and frankly, a lot are ready, willing, and able, but they have to be pushed. And you just have to remind them of the most simple thing in life with this is what you've been doing probably, even in undergrad in some kind of research lab. And then you either, went to a master's or to a PhD program or whatever it is that they did, but you think about this all day, every day. But I got to tell you, ma'am or sir, these slides are confusing and we can't let these go. And I know you might be about to tell me they've worked before, but just because they've been presented before doesn't mean they worked before. Just because they weren't objected to before doesn't mean they won't be objected to this time. So let's simplify it. Your words are so good and so powerful, they should not be reading whole sentences. There's no slide. The only messy slide you should ever have is how many times your person went to different appointments. That's allowed to be messy because it shows how their life has so changed. But words and too much, no way.
Yeah,
Stop the nonsense.
along that same line, just kind of given modern realities and society where it is now, have you seen that your presentations, any form of tech, and especially for opening or closing, are those getting shorter in any way to try to really kind of pare it down to the essentials of the story, since we're in such a tell me what I need to know and then kind of be quiet kind of culture?
Yeah, well, I think the answer is we always make what do you like I don't want to be wrong about this, but I'd say we usually get rid of 30 to 40% of the slides we made. We made. Um, in other words, they seem like a great idea, but as we're trying to pare it down, we even tell ourselves, no, this is too much. So yeah, this is the problem. And I think some people relate it to SpongeBob. I think this is where some studies came out that you're switching every couple seconds in order to keep attention. And it's been blamed for, some of what's going on in society. I don't know if any of that's true, but what I do know is never assume the jury's stupid and give them what they need, but don't give them too much and don't belittle and don't. I hear I hear weird things said out loud in court, like, "Well, you probably have never heard, but," and it's like, um, now you're gonna like, what if I've heard that? You know, what if my best friend's dad growing up, worked at NASA, which is true, by the way. Maybe I heard a little bit of weird stuff that a normal person didn't get to hear. And we just have to quit those assumptions and it helps us. So, yes, always dumb it down. Show it to a focus group. Ask them stuff like, what do you think of this slide I made? They will tell you maybe it's not so good. And we have to take it on that the chin to kind of say, are we actually doing that? Are we taking the time to even ask people, do our slides look good?
Yeah,
Do maybe you've used the same slide maker forever and you just think they're working, but it's actually you that's working. Maybe it's you, Kenny. Maybe it's not your slides. And if you got your slides a little bit more fine-tuned, you'd even have better results.
it's hard sometimes for folks who, they might have spent 10, 15, 20, $30,000 on a demonstrative, or they might have worked hours upon hours upon hours to put together this, 75 or 100 slide presentation. What recommendations or advice do you have for people to, even if they've invested the time, even if they've invested the money, to be able to just let go and just say, you know what? I spent the money or I spent the time to find out I didn't need this, to kind of, you know, uh, disinvest or divest, I should say, from whatever it is versus being attached to it simply because you spent money on it or created it.
Well, let's talk about that a little bit. Like, um, do you remember your first date with your wife?
I do.
I assume you had some kind of plan, but you had to be flexible enough to know that if it wasn't looking good, you might not do it. So, for example, if let's say I'm picking someone up for a first date and I think sushi's the call, and I ask and learn that person hates sushi, I need to be able to say, do I cancel the whole date or do I change where we're going? And it's funny you bring this up, and the listeners may not believe this, but I actually did. We didn't talk about this, but in our last trial, we had like a $35,000 demonstrative and ended up letting it go. It just never worked to get it in. And the fight that we were going to have in order to make that work wasn't going to work. It was going to take away time and some of our credibility. And then you're like, how important was that? Now, I did take two still shots from an animation from that, and that's all we used. And you could either say, hey, that's whatever, 30,000 bucks or whatever it was, which is, no joke, by the way. I don't think that's a joke. In fact, we're all sitting around your guts to say, can we work it in on this one? Can we work it in on that one? Where are we going to do it? How are we going to do it? And the answer is let her go because like a date, if something in this relationship, this judge attorney relationship, this attorney jury relationship wasn't going to make sense anymore, you got to let her go. And it might hurt your soul. It might make you feel like, Why did you ever do it? But frankly, you might not have got where you were mentally had you not gone through that process and had a perfect thing teed up if everything fell your way. But with any kind of demonstrative, that especially a professional animation, be prepared for the judge to shut it down, the other expert to tear it apart, your own expert not quite lay the right foundation for who knows what reason, um, and let it go. Because the more you hold on to that kind of energy, the more it's going to drag down the real energy. And you ask yourself, because I would ask you this, like, Kenny, is there anything, if I told you I have a rule in my courtroom, my rule is I've been overturned so many times on stupid animations and people have added music and sympathetic music and stuff that just wasn't 100% accurate. And I've gotten overturned on it when I tried to let it in. I have a rule. And I'm just telling you this on day one of trial because I forgot to tell you some other time. There's not going to be any animation by the defense or the plaintiffs. Now, you, Kenny, can you still tell the story anyway? And I
Yeah,
think the answer is always yes. Because you, if you can imagine that and go there and could you pick up this the sees and the smells and the hears and actually tell what you needed to tell in that animation, you're going to be fine anyway. But you'll see people get so connected, they waste time and accidental credibility because they usually don't do this behind closed doors. They try and throw it up, they do something silly. It's not quite what they gave him a rendering before, but then they changed the background, then defense objects, little things. Because does it matter if you change the background color? No, but if what you sent to the defense looked slightly different, they're going to stop you because they're not trying to stop you because they actually care about the color of the background. They're trying to create a reason to stop you because they want to shut you down any way they can. That's their job.
exactly. Yeah, and I think, kind of another related practice tip there is, not getting overly connected or dependent upon and reliant upon one of the experts in your case. If it's a treater in your case, if there's some element of the case that you can get to the same point by other means. I mean, we've got involved in cases, I'm sure the same way you have, where, there may be a big old life care plan, or someone may have spent a lot of money on a certain expert. And, we got to ditch it. And it's it's hard to explain sometimes why, we are basically ditching, I don't know, big life care plan or 25,000 bucks for an expert here or there, whatever it is, when it's like, again, when you take a step back and you ask, all right, when I look at the full picture of this case and when I play it out and I look at all the different working elements, we don't need the massive freaking bass drum to get the symphony to life. We don't need the lightning strike in the background of the two people kissing to signify that these people love each other. In fact, we're just going to distract away from the core element and where we really want the focus to be.
No, you're exactly right. And I was going to show you, I'm going to share my screen. I don't know if this is going to work. You can, we'll see, but I'm going to show you, like, I'm going to show you one little trick here. Is that okay?
Absolutely.
So this is, I just real quick uh hid my client, but see this is my client on the left and his house on the right. And I have a case that has to do with what's going on at his house, right? So how can I start to tell some of what happened? In mine, I had to recreate this house. So what do you think it would cost a visual guy to go make this in CAD or something?
Oh, man. It's got at least one, it's got a comma in it.
Yeah, and so can you see in there below the white fence it says 2020 Google? I took this, of course, from Google Earth, right? There's no
Yep.
question about that. Let me go to the slide that I made where I'm just trying to make it look professional, but what everybody here is capable of doing. Can you see this one now?
Yep.
That's his house. Do you see that?
Yeah.
Now let me show you. You can still see this screen, right? Can you
Can
still
you
see my
bring it back
screen?
up for the testing?
It shows the house though and the thing, right?
Does. Yeah.
So this is just, you're looking at my keynote. This is a real trial. This is that $63 million verdict. But if I click on this, and I'm trying to edit it. All I did here was make the shapes. This is like me. So I put the picture of his house below this. I then made the shapes that looked like a house on top of it, if that makes sense. And I've recreated an image that was really important to me to make them understand this picture. See this guy that I'm moving around? This is from the actual evidence.
Hmm.
I just made it so they could understand what boring looks like. This, I went and Googled a picture of the bore. Now, in this trial, we were prevented from telling anyone that this house was torn down. So I use this image to show how deep they bored. See this one down to 20? They bore 20 feet down here for number six. This is test number six. What do you think a jury's thinking if this bore goes through this house and through this machine? This is how you'd make it happen, right?
Right.
I got around telling the jury that this house was gone with them knowing that it's gone because see over on this left little menu that I just took Google Map, overlaid the where the chemical pit was, those dots we put on where was this testing done? Those are individual dots in my thing in that we literally made. I made little blue circles and put them right where the engineer said they were. And we let the jury know, hey, here's the house, here's the dirt, here's the water level, and how deep it went. And so this is just a simple example of who can do this. If I want to, I made this little door. If I want the door to be red, I make it red. If I want it to be orange, I put the shutters on by again laying his house picture that I first showed you on there. I'll show you one more time. That's his house, the garage, the whatever. It's not perfect, but what you see is it doesn't need to be perfect to later tell the story. And this, anybody that can make a shape, you go here, make a shape, pick the color. I want a red garage door. I'm going to move it over there and make it red, right? Like we have to own this stuff, Kenny. And again, that was all silly, but that's how easy it is to start to tell what our jurors need to hear, and it helps them imagine this stuff all the way through.
And the part I liked about it when you were just showing with the house and then with the bores underneath it, in that image, because the house is there and because the house has not been torn down, it's easier for me to visualize, to imagine somebody living there without any knowledge whatsoever on all the drilling that had taken place and all the poison that was directly beneath his bedroom.
And that's what we needed, but you got to be the teacher. And I'll do one more. And I know that you didn't ask me to do this, but
Good.
so I'm the teacher. They're there. Here's oil. So you go, this is just, I want to teach how ugly and stuff it is, right? Like if we talk about the American oil boom, this is what we're talking about. This is what we want people to be thinking about. Why? Because it's dirty and it's ugly and it hurt. Look how close in the upper right there, Kenny, all those the derricks are to one another, or the wells are, I'm sorry. Like that's what was going on in our country. And you teach them, hey, this is where oil is in America, you know, but this was a California case. I'm a Wyoming guy, so you see a lot in Wyoming, but hey, let's talk about California. More specifically, let's talk about the Santa Maria Basin, and right off the Santa Maria Basin is stuff in the water, see, and on land. So see this transition? Now I'm going to teach them, hey, the surface estate, that's where someone lives. The mineral estate, that's where they go get this stuff. See in the background there, see that benzene molecule there?
Yeah.
I'm becoming the expert and see the transition. Like these are transitions that Keynote, excuse me, does at PowerPoint, but see how I took that little thing, blew it up, and I'm teaching. And then I go into phases. See how everything's blue? The blue there matches the blue up top. Hey, it starts with exploration. That's when geologists do this and that. Then they go drill it. That's where they put the hole in there to complete it. Then that's what stops it all before they're coming ready to get it out, before they can produce it. That's the completion phase. Then production, you guys have all seen those horsehead, jacks all over. That's how they get the oil out of the ground. That's creating the pressure to bring it up out. And of course, the money comes after that.
Hey,
And
Jacob, real quick, for the folks who can't see it, the money was depicted in a drop. I mean, it looks kind of like a teardrop, but it's a drop of oil. I just out of curiosity, whose idea was it to make sure that it was the drop with the dollar sign? It's pretty, it's subtle, but it's like, oh yeah, that's what we're doing here.
that's me. Now, a team member, like as a team, I just happen to have a background in oil and gas, so this part was more me, but that's how I see it, right? if you don't explore it and you don't drill it, you don't complete it, you can't produce it. But if you produce it, that's the money. And so subliminally, and it's not even so subliminally, everyone can understand this is all about profit. This is
And
about profit.
and the nice part too, though, is it talks about profit. It's just the way that you've got it visually demonstrated here with a drop that's got the dollar sign in the middle for folks who can't see it, where it looks like a drop of oil, but could also be a teardrop. And it may be, I doubt it was unintentional, but tying the money they're making from the drops of oil to the pain and the harm it causes others is well done.
Yeah, and I think, God, I never thought about that. But do you know what? What if a juror did? And since we're on that, I'm going to show you one more thing, and we've probably gone over time, but I want to tell you how we use pictures to uh, um, kind of get to the end because this was the first time I tried it and I think it was effective. So I'm going to pull up the closing real quick. So now we're at the closing stage and we're trying to give some kind of visuals of what really happened here, right? So simple things. This is a Google image, the dominoes, but then I went on here and, added this language. And Brian and Aaron and Ansley helped with this. I wanted this to be, this is always the thing that starts it, right? But is that a defendant? Is it you name it, right? Whatever it is, it's always it's better when it's a corporation, but you can create anything that has this chain of effect. You need them to do it. Now, some more custom things I did here, we always said the buck stops here, right? This was a non-delegable duty. So when you have a non-delegable duty, and really this didn't start out this way. We told them in the opening the buck stops here, but by the closing, look what I made on Photoshop. Right? We it became so clear that they just weren't accepting any responsibility. The buck stops anywhere but here. And all that was is you take this first image, and I cut it and I blurred out all that stuff or blocked it out, turned it brown, cut it in half, lengthened it, and then you can see I just typed right on top of it when I created my own. And again, this is stuff that a lot of people's kids might be able to do for them. That's how easy some of this is, but you gotta mess with it. But I want to show you really how.
Jacob, some I liked on the domino slide, because we've talked about the domino, this is what set everything else in motion, or this was the spark that lit the fire. This was the cue ball, whatever you want to use. But what I really liked was not only did you have the dominoes, but the titles that you had on each domino for the different things that the defendant did uh, that harmed your client, that then specified, hey, harmed Mr. Wright. And then after that, which I really loved, was deny, deny, deny. I mean, it's taken a good idea, which is the domino analogy, and just making it so much better. So again, credit to you and your team for taking something a lot of people do, but asking the question of how can we make this better? How can we improve it? How can we just get a little more out and really bring it home, which I think this slide does.
That's right. And you're saying like you're trying to get them saying, hey, they start I all day, any day, you, me, any lawyer listening can say they started, a domino effect that would never came back from, right? Anyone can do that. But if you put this on there and you show the tortfeasor, the first domino, and then in this case, we have five dominoes, you get to make their brain think, oh, yeah, the domino started when they poisoned the ground, but then the next one is they hid the poison, then they didn't warn, and then they sold the property by walking away, and then Mr. Wright was harmed in this case. And then all they did after that was deny, deny, deny. And they can imagine any number of other dominoes in their head that they've already been thinking about. Um, and that's it. And I'll hit a couple more like anything you agree on, show symbolism of an agreement. This is not hard. This isn't rocket science. This is Google. And then go over what you agree on. This, we had someone that didn't show up to trial. So in the first, even in the opening, I use this picture. See this big shiny blue building? It's actually not that color, but I turned it more blue to match our slides. But guess what that is? That's Chevron headquarters. And guess who this guy is? I blurred out a guy's face because Chevron never came to this trial to say sorry. And Unical is owned by Chevron, just so you know. They never came to say they wish they did it different. So we kind of I did this part of the closing, Brian did a rebuttal to say, you never heard from anyone here. And see that what I always told you, the back of every slide, see the benzene molecules there. And then as we go through and we talk, remember I talked about non-delegable duty, Chat GPT helped with this, believe it or not. Because you would say, oh, who wouldn't have thought of the captain of the ship? Well, I didn't at the right time, but see how I put the blue bands match our blue color of that, you know, the ship's mast matches the blue, but this was the theory came. And then on this slide, I said, in this case, the defendant is the captain of the ship and it couldn't blame other people. Now, do you know what this picture is by chance?
The only reason I would is from other conversations we've had, but for folks who don't, what is it?
This is the the famous boat captain, where they show him jumping off the ship with while other people were still on it, and those people died. Now, I don't have to say, hey, remember the South Korean fishing or the vessel where the captain jumped off? No. But for anybody that remembers this will trigger something. And if they don't know it, they don't need to. And finally, um, this was the first time I've ever done this one. But as I was talking about what reasonable compensation is, I wanted to, and this is a build slide, but you have it all here. You know what I mean? Um, if if this were reversed, Kenny, and it was Union 76 that, somebody ran into their gas station and hit those pumps and hit that cultured stone in the metal and caused some damage there, they would be able to come to court and say, hey, that's 30 square foot of cultured stone. The gas pump is $5,000, whatever it is. Nobody would have any problem doing that, right? It just wouldn't happen. And that picture never came up in evidence, by the way. This isn't about a Union, 76 gas station. But I was trying to teach the jury, when they can only see that picture, it'd be really easy to figure this out. Then the next one that popped up is the middle one, which was their first corporate headquarters. And you can see it's kind of an old picture. And I said, and God forbid, and nobody's in the building, but if that big building there, if that blew up in the middle of the night because of a contractor's negligence, they could walk into this courtroom and ask you to rebuild that whole big, huge, glass building, whatever it is. And you wouldn't have any problem with that. And then we stair step to their offshore drilling rig. And then I said something along the lines of, and if that blew up, and again, there was one Union 76 employee on there that died, they would come into this courtroom and want you to rebuild that whole offshore oil platform. They would want you to give them, they'd want you to pay for their employee, even if they're not making a wrongful death claim for them, they'd want you to pay to replace them and a lot of money. And then, even more importantly, every day that it took from the time that blew up until that time that man died, they would want the exact value of every dollar of every drop of oil they couldn't suck out of that ocean at the time because of somebody, doing that. Nobody would have any problems with any of that. We can replace the gas station. We can rebuild the building. We can pay them to get a new supervisor that was killed. We can pay them for everything to go back. And then they start to realize, wait, that's exactly what they would do. This company, if that happened and someone else was negligent, they'd come into this courtroom right now and they'd sue for that. And they'd expect you to give every value of every drop of oil, the cleanup, the lost profits, you name it. They'd want you to do it. But you got to visually give it to them. You don't just say it. It's not good enough to say what I just said. And again, I didn't say it well, but actually, you have a little bit of leeway of not being so well if you're creating an image to get their brain to think about it. You can be more
Right.
of a mediocre lawyer like me if you can tell a better story with pictures.
Well, I mean, I think that the better lawyer is typically the one who's the most persuasive and effective. And if the effect is greater through the use of words and visuals and pairing the two, and it's more memorable, and it's more persuasive, and it's more consistent, and it's more credible, whatever other adjectives you want to attach to it, at the end of the day, that is what's better. So,
Yeah, and if you think about it, Kenny, everything you saw, I made. And did it take me a little bit more time? But think about how much time I would have made if I sent it to a designer and they didn't give me what I wanted. Then they send me a big file back. Then I send them the results back, and then it goes back, and then it goes back, and then there's this version and that version. They got one slide right and three slides wrong. But the fact of the matter is, our obligation, this is an obligation, this isn't a choice, that we must give learners, different style learners, ability to understand what we are doing, right? And if you have an auditory learner, great. And you're a great orator, great. But if you have a visual learner and you're skipping that piece, you are, in my opinion, committing malpractice because you're missing an opportunity when we know there's only a couple ways that these folks get to learn. We don't get to give them all I mean, the evidence is the equivalent book to read, but did we give it to them the right way the whole rest of the time? So anyway, you put me on a soapbox. I've taken a lot of time, so I apologize.
No, man, no need for apologies. For thank you for the time. Thank you for standing on the soapbox and for standing up for a lot of people really all over the world at this point. Uh Jacob, for folks who want to get in touch with you, questions about tech, questions about trial, all points in between, what's the best way for them to do that?
You bet. And I hope you know I actually love this stuff. I can share samples when people need. I can recommend things to the extent people want recommendations. But I will spell out an email address. It's JNAO team at TL4J.com. So I'll say it phonetically. Juliet November Alpha Oscar team at TL4J.com. You can always, I guess, call me. I don't really like do any voicemail kind of stuff. I don't know how you are with that, but there's too many modes of communication, but you can texting's pretty good, 307-267-9432, or just go to tl4j.com and find me. But I love this stuff. I'm passionate about it. I just my gosh, there's something cool about being able to tell a story multiple ways at the same time.
Yeah, and you nailed it. It's not about tech for tech's sake, but if you can tell a story in different persuasive ways all at the same time in a way that's going to be more effective and beneficial for the person that you're privileged enough to represent, then you should.
Yeah, and just remember they take it back with them. Maybe I didn't connect as a person, maybe it was my accent or my style or, something I'm not great at. But there was a picture in there that they take back to that jury room, and that's the one that helps them on that particular issue. They will fight for you over that very specific issue. They'll be like, no, they drilled down 20 feet, but remember, they found the poison at 3 feet. Remember where those red lines were right above the water? That's where the poison was. It went to 20 feet, but that's not important because the visual, and I didn't tell you what I was saying in that, but they didn't have to go 20 feet. The poison's right below the house where the red was, right? Red's always bad. And my gosh, I'm telling you, jurors will use that and go do work for you if you do it right. And it should all be honest. Don't mess any of this up, but give a visual on any slide that you have words, put a visual. Now you got both people, right? Because there's only the only thing we're really missing in trial is kinesthetic too, but sometimes you can pass something around. Not always, but give them a way to do this.
Yeah, I love it, man. I'm a big believer if it's really important enough for you to talk about, then it's probably important enough for you to show them.
Ginny, you and I are on 100% the same page.
Listen, man, thank you so much for coming on the podcast. Not only can you listen to this podcast, you can also watch it. Uh, and so I hope you do both. Our guest today again has been Jakob Norman from Trial Lawyers for Justice, and we look forward to talking with all of you soon. Take care.